call it potable alcohol, call it every alcohol, I would humbly submit that the proper way of interpreting, for your lordship's kind consideration, is to take it in the reverse. Everything except denatured spirit will be alcoholic liquor for human consumption. Because unless it is denatured, it is alcoholic liquor for human consumption.
Everything except
Denatured spirit. Because since your lordship is sitting in 9 judges, we don't want another round of litigation. Is it alcoholic liquor fit for human consumption? At what stage you levy, etc. And the reason, sorry. Lord, why I say this also is because of, on this tax aspect, Lord, because of this, we have to also see the economic consequences of what we hold. This is Sikri refers to Richard Posner's theory of law and economics having an interplay. Suppose your lordship says, as held in synthetics and chemicals in para 85, they say it should be fit for human consumption, para 65. Then what happens is state has no power to levy any excise duty unless it's a ready-made whiskey, rum, gin or beer. At the ENA stage, it has no power to levy. That ENA is actually for human consumption. Part of it becomes unfit by adding a denaturant. And why do you add a denaturant? Because the state says, if I am going to lose my revenue, you better make it unfit for human consumption, then you clear it. So my humble request is, keeping in mind the interplay of law and economics, if a lordship takes the view that it should be fit for human consumption, it will have deleterious effects on the state finances, particularly after GST, where as part of our new fiscal federalism, the taxing powers of the states have been drastically reduced. Today, only major sources, alcohol, potable alcohol that is, and petroleum products. And lordship has interpreted 279A4. They say that once the GST Council decides to bring it into the levy of the net of GST, then state lose the power. But today, the main source of real alcohol. So my humble submission is, if we use the word fit for human consumption and take it to that stage, it will have an extremely adverse impact on the taxes of the states.
In fact, the word fit is not there.
Not there.
for human consumption.
Not there. Not
Is it there anywhere?
No, not fit for. I checked whether
by interpretation, otherwise it is for.
Yes.
So it is capable of.
Yes. Actually, I tried to do a legal search fit for. I got some 6,000 entries. Wherever there is fit and for, it is showing up. So it became very difficult. Even statutory provisions, I could not say. There's no, only Anwar Khan says that consumption doesn't mean final consumption. As long as the goods can be consumed, it is enough. I'll give you an example. Suppose you say rice. Now, rice by itself is for human consumption, but till we make it put into a pressure cooker and make it into rice, or wheat is converted into flour or atta or maida, it is still wheat. It is still for human consumption. So in the same way, ENA, in my chart, after the secondary process of distillation, first substrate, rectified spirit, ENA. Then we branch out into drinkable or industrial. So my humble request is, keeping in mind 366(12)(a), the power of the states to levy tax should be on extra neutral alcohol. Whatever is not denatured.
Really, in that sense, dealing with tax per se under entry 51, are we? No, dealing with the ambit under entry 88. Your contention is that we are entitled to levy fees.
No, I'm on a different point. I'm saying that I have to get over the synthetic, because synthetic 7 judges say it has to be fit. In para 65, they say
yes,
it is fit. It's like a beverage. They use actual and they put it in italics with emphasis. Till it's a beverage, state has no power to levy tax at all. That, in my submission, is too extreme from the state's perspective. And it may lead to a conundrum, because So, my lord, sorry. May I continue? So, my lord, this is the request.
Or human consumption is that it may be eventually destined for human consumption.
It has the potential to be
Potential
to be meant for human consumption. That's the point. Now, my lord, I go to entry 8 and entry 33. Entry 8, my submission, my learned friend has elaborately discussed the whole point. My submission is entry 8, as your lordship knows, is not subject to. But my lord, just Nagaratna asked the question, what is the interplay of 246, 2 and 3? There at my
246 1. 246 1 also.
246 1 also. Please see, my lord, 246 1, 2, 3. And I would request your lordship to read it in the context of 254. 246 1, yes. Notwithstanding anything contained in clause 2 and 3, Parliament has exclusive powers to make laws with respect to any of the matters enumerated in list 1. 2. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also have the powers to make law with list 3. 3 is very important from my side. Subject to 1 and 2, the legislature of any state has exclusive powers to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule. So lordship will kindly see, the rule is exclusive power. In the concept of a federal structure, exclusive power is there. And my humble submission is, unless that legislative entry uses the word subject to, the power of the state legislature should be plenary.
But subject to really makes it clear that the power of the legislature of the state is, in that sense, I wouldn't say subordinated to
Parliament.
but is subject to the power of
Yes.
Parliament. And
Very interesting. Very interesting. Now, let's take a law with regard to entry 8. Manufacture, production, possession, transport. Intoxicating liquor. That is to say, manufacture, production, possession, transport, sale. This is given, exclusive power is given to the state. Now, my submission is, if your lordship now reads 254, I am saying the question of competence. Just because Parliament is supreme, it does not mean it can make a law which has been exclusively given to the state.
undoubtedly.
Undoubtedly. So, yes, that's all. So 254, lordship has got the point, so I don't belabor on that. Please see 254. I'm saying, I'm requesting your lordship to read 246 1, 2, 3 and 254 as an overall scheme. 254 1. However, I'm not going to 254 2 because entry 8 is not in the concurrent list.
Correct.
If married not 2, sorry. Yes.
The word subject to clauses 1 and 2.
Yes.
Does that mean that where Parliament has undoubted power to make a law and has made a law in exercise of its jurisdiction to make a law on the union list, the state also has a power to make a law on a subject which falls in the state list?
Yes.
Both have powers and
Yes.
both are acting within their realm.
Yes.
The law nonetheless made by the legislature of the state ought not to entrench upon the law made by by Parliament.
True. But I'm going in one other way. Repugnance will come where it's a law validly made by Parliament. There is another law made by the state. Two can't collide and coexist. Right. Then in that case, supremacy goes to Parliament. So if the two laws are colliding with each other, then Parliament law will supreme. I am requesting a lordship to interpret entry 8 to mean, please see 254 1. If any provision of law is made by the legislature of a state is repugnant to any provision of law made by Parliament. But what law made by Parliament? Not any law. Please see the next after the comma. Which Parliament is competent to enact?
with respect to one of the matters enumerated in the concurrent list.
Concurrent list. No, there my submission is
Or
after comma or to any provision of an existing law. My submission is the first part, that is up to Parliament is competent to enact, can be a list 1 versus list 2 law. Then there is a comma. Or to any provision of an existing law with respect to any matters enumerated in the concurrent list. Then subject to. So now the second part, concurrent list, or to any provision of an existing law made. Please see this now. I'll put it this way. There is an existing parliamentary law. That existing parliamentary law is with respect to a matter in the concurrent list. Any law made by the state will be repugnant, will be void to that extent. I am not on an existing law. I am only trying to interpret the scope of list 2. I am trying to say the words between the two commas, which Parliament is competent to enact. If entry 8 has given exclusive power to the states in the context of manufacture, production, possession, transport, sale, Parliament has no competence to get into intoxicating liquor on those fields. Because it's not any law made by Parliament. It should be a law which Parliament is competent to enact. And my submission is that non-obstante clause only talks of a law, competent law of Parliament. Suppose tomorrow Parliament makes a sales tax law. It's not competent to make it. Then you can't say no, Parliament in the federal structure is supreme. That's the submission word. So my humble submission is these words are very important, which Parliament is competent to enact. I have also this theory that occupied field should not be necessarily restricted to concurrent list.
No, therefore, the scope and ambit of this expression in entry 8, intoxicating liquor, is again important.
Yes.
Because if there is something beyond intoxicating liquor,
Yes.
then it can be read in the first part of
Yes.
Article 254,
Yes.
read with subclause 1 of Article 246.
Yes. But my answer.
They go together.
Yes, my answer to that is this. Now, intoxicating liquor has not been defined.
Yes.
It has not been defined. What do we do? Mr. CJI goes into various aspects of different types of competence. Gannon-Dunkley, the test is the classic test. Suppose a word is not defined in the Constitution. Then find out if that word is nomen juris. If that word has got a definite connotation over passage of time, then adopt that. Therefore, what happened in the Gannon-Dunkley's case? The Madras government, then Rajaji's government, amended the word sale to include works contract. That was challenged. And incidentally, as brilliant as the Supreme Court judgment, the classic Madras judgment is equally good, Justice Satyanarayana's judgment. What they say is, you have got the power to tax sale or purchase of goods. Sale is not defined. Then can you say state government can say sale includes works contract? What Justice Venkatramaya says in Gannon-Dunkley is, sale is not defined. But sale is nomen juris because by tradition, the Sale of Goods Act, which was earlier in the Contract Act, sale basically means it should be goods, consideration should be in money, and there should be transfer of property, buyer and seller. If those three things are there, it's a sale. In works contract, that is absent. So he said, you can't expand your taxing powers by giving artificial definition to the word. In the context of intoxicating liquor, my submission is, all the acts are here. We have made a complete chart. Spirits Act 1880 says spirit includes denatured alcohol. So intoxicating liquor today, India Mica, FN Balsara, all have said intoxicating liquor includes denatured spirit, because if your lordship sees my chart, the color chart, denatured spirit is born out of intoxicating liquor. In a sense, it's the offspring of intoxicating liquor to which denaturant is added. That's all. So you have molasses, you have rectified spirit, you have extra neutral alcohol, and then one branch goes to denaturing. So my submission is intoxicating liquor in that sense. There is no such thing as industrial alcohol coming out of somewhere. Industrial alcohol is the offspring of intoxicating liquor. And my submission is that subject to in 246(3), your lordship asked, that subject to must be a subject to in the Constitution. And a legislative entry cannot be cut down by a parliamentary law. That's why they say subject to entry 24, lots of mines and minerals, subject to, subject to. Incidentally, in list 1, entry 32 is the only list where it is subject to a parliamentary state law in the constitution. Now, my lord, so my humble submission is entry 8 should be read in such a way that the state's power is supreme, because tomorrow, if they want to levy a rent fee, a regulatory fee, so we should completely demarcate what is the territory, legal territory for the states. And I would submit, as the statement of object says, let the Lakshman Resha, let the borderline be the time of removal. Up to the time of removal, it is the state's jurisdiction. When it is removed, depending on its destination, it becomes a state tax or it becomes a central tax. Now it becomes a GST. Now, I go on to entry 33. Lordship will kindly see entry 33 is substituted by Article 36 by the third amendment to the Constitution. And why was it done? My lord, if the Lordship kindly sees entry 33 for a minute.
They added B, C, D, E.
Yes, not just that, there was a small change. If your Lordship kindly takes, I've got the old entry 33. What that is? It's just one page, so I didn't put the whole government of India Act. Huh? It's in Tikarang.
Now use the word industry.
Yes.
The earlier one was in plural, industries.
If your Lordship kindly sees where the control of such industries is, yes, your Lordship is right. Lord, one thing of 33, is your Lordship seeing the old act? Not? I'll see the old act and then go. Please see the old one. Trade and commerce in. So Lordship can link it to 26. Production, supply, distribution of. Link it to 27 of list 2. The products of industries where the control of such industries by the union is declared by parliament to be expedient in public interest. Now, why was the need to amend it? Please come to 369 of the Constitution.
They of course also added and imported goods of the same kind as such products.
Yes. No, please see 369. One of the temporary provisions in the Constitution, 369. Where's the list of Lordship has got 369.
Yes.
Temporary power of Parliament to make laws with respect to certain matters. Notwithstanding anything contained in this Constitution, Parliament shall, during a period of 5 years from the commencement of this Constitution, have power to make laws with respect to the following matters as if they were enumerated in the concurrent list. So they take a legal fiction with regard to specified matters, even if it's in the state list, Parliament gets power. Now, please see what are the matters. Trade, commerce within a state, in the production, supply, distribution. Again, they adopt the language of 26 and 27. Cotton and woolen textiles, raw cotton, including gin cotton and gin cotton kapas, cotton seed, paper, newsprint, foodstuffs, cattle fodder, coal, including coke, derivatives coal, iron, steel, and mica. Now, this is what's going to lapse in 1955 because it has a shelf life of 5 years. So if your Lordship sees the statement of objects and reasons of the third amendment, Parliament felt it necessary that though 369 will lapse in 5 years by 1955, Parliament should continue to have control over certain essential items. That's why they came with this substituted entry of 33. Now, please come to entry 33 for a minute. Lordship will note that entry 33 of list 3 Lordship will see, my lord, trade and commerce in production, supply, distribution. So there are 5 activities: trade, commerce, production, supply, distribution. Now come to A, products of any industry. As the Lordship said, now it's industry, where the control of such industry by the union is declared by Parliament by law to be expedient in public interest, and imported goods of the same kind of product. B, C, D are some of the items from 369. Not all.
Yes.
Not all. Because iron and steel has gone to IDR Act, coal has gone to Mines and Minerals Act. One more distinction Lordship will note. One is industry, A is industry, B, C, D are agricultural items. Mr. Basu in his commentary says this is a cut at federalism. This agriculture is exclusively state, but you have put trade, commerce, supply, etc. in list 3. Now, the scope of 33 vis-a-vis 24, 25, 26 has been very well explained in a Supreme Court judgment, SIEL versus Union of India.
No, that is under 369, it was held to be in concurrent list. Therefore, they brought it to the concurrent list.
No, what happened actually,
Under the
your Lordship is right.
Under the
369
temporary powers,
yes,
even though it may be agricultural products, under the temporary powers, it was under the
Yes.
concurrent list.
yes, yes. What they did was they created a legal fiction. They said for the first 5 years, although all these items are in the state list, they will treat it as if they are in the concurrent list.
That's first to give Parliament the power to legislate.
Yes. So now what happened is they didn't want the whole. See, if
So they brought some of those items in entry 33.
yes,
Which is,
which are agricultural items,
Right.
which are agricultural items.
but they continued it in the concurrent list.
Now it's forever. Now it's forever. There's a very nice, very short statement of objects. Parliament
Raw jute was not in Article 369. No?
Sorry, my lord.
Raw jute was not in Article
Only
369.
jute was there.
Was jute there?
One second. I'll just subject to memory. My lord, 1 second. No, jute is not there. Your Lordship is right.
Of the subjects in clause A of Article 369 were not brought into.
No, not all. Not all. Not all.
Just these limited
Yes,
items.
yes, yes. Because, for example, my lord, cotton, woolen textiles, iron, steel have gone to Schedule 1 of IDR Act. So they are not in BCD, but they are in A.
Right.
They are in A.
Now what does CL say?
Tobacco also not there.
Sorry.
No, my lord, tobacco not here. Not there. Sorry, my lord.
What does the judgment in CL say?
CL. That shows the interplay of 24, 25, 26 and 52. And they say that what is in entry 33 of list 3 is out of entry 52 of list 1. Yes. Lord, will be volume 5, page 2209, PDF pages 2217. 2217.
Hey.
Lord, the initial facts may be slightly important. What was challenged was some molasses order, which was upheld by the High Court and Supreme Court confirmed it. Kindly come to page 2213.
2213.
Bench of 2 judges, 2213. I'll just read para 2 and 4. The appellants in these appeals have challenged the constitutional validity of Uttar Pradesh Shira Niyantaram Adhinayam, being UP Act 24 of 64, which received the assent of the President on so and so. The occasion for this challenge appears to have arisen on account of orders passed by the Controller of Molasses, Excise Commissioner UP, under Section 8 of the Act, read with Rule 22, dated so and so. Now, para 4. Under the said orders of the Controller dated so and so, different percentages of graded molasses were reserved for distilleries and industries based on molasses and alcohol in the state of UP. The reserve quantity under the said orders was required to be sold at prices fixed by the state government. Now, please come to page 2214. They expressly extract 18G. Now, my lord, since your lordship has got page 2214 at 18G, to save time, kindly note, it says regulation, supply, distribution, trade and commerce. There is no production in 18G. The word production is not there in 18G. So out of the 5 items of entry 26 has 2, trade and commerce. Entry 27 has 3, production, supply, distribution. So 2 plus 3, 5. But here only 4 are there, whereas Essential Commodities Act Section 3, all are included. So the point is, even under the IDR Act, Parliament has not preserved to itself, even by notified order, they can't cut into production. So now please come to para 10, page 2215. They see the entries. Lordship will just note entry 8 was not there. Now please come to 11, they refer to Calcutta gas. Now please see 12 and 14 are important. May I read 12 and 14? May I read? While dealing with entry 24 of list 2 and entry 52 of list 1, this court in the above case considered what was meant by the term industry, which was used in both these entries. This court held that in the first place, where whatever be the connotation of industry, it must bear the same meaning in entry 24 of list 2 as in entry 52 of list 1, because the two entries are interconnected, and giving differential meanings to the word industry in the two entries will snap their connection. This court further observed that ordinarily industry was in the field of state legislation, but if Parliament makes a relevant declaration or declarations, the industry or industries so declared would be taken off the state list and passed on to Parliament. This court in that case was concerned with the interrelationship of 52 of list 1, entry 24 and 25 of list 2. The last entry expressly dealt with, no, your lordship has seen that, I'll skip it. If we apply the same principle of harmonious construction to entries 24, 26 and 27 of list 2, the term industry in 24 would not take within its ambit trade, commerce or production, supply, distribution, which are the express province of 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade, commerce in or production, supply, distribution of the products of those industries which fall on entry 52 of list 1. For the industries falling in entry 52 of list 1, these subjects are carved out and put in entry 33 of list 3. Now please see 15. I'll just come to placetum E, below that. Just above placetum F. The products of the industry, lordship has got it. The products of the industry would be comprised in entry 27 of list 2, except where these products were of a controlled industry, where they would fall within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and 27 of list 2 would not be covered by entry 24 of list 2, and similarly, subject matter falling under entry 33 of list 3 would not fall under entry 52 of list 1. I've done only one point. There is a controversy, since your lordship is sitting in 9 judges. What happens if a law is made but not notified? Suppose Parliament makes a law but doesn't notify it. Does it occupy the field? If a state law is there, will it be repugnant to that? Or there is a Constitution Bench judgment of Mar Aprem Kuri, which says that the Chit Kuris Act, they made a Chit Act by Parliament, but it was never notified. So the Constitution Bench says law made by Parliament is different from commencement of the law made by Parliament. So just by making the law, Parliament occupies the field. My humble submission is that may not be correct, because Mr. Dwivedi also read, repugnancy must be in reality. So my submission is, unless the law is actually brought into force, the law made by Parliament must be the law made by Parliament which is in force. Lordship knows the Hire Purchase Act was made in 55 but never notified. Take service tax. 88th Amendment, never notified.
Section 2J of the Industrial District.
So to that extent, mar aprem curi, my lord, which makes a distinction between law made by Parliament and commencement of the law made by Parliament may not be good law. Would the Lordship like to cite it, or I'll reserve it later, my lord. If we get time in reply, I'll mention that here. Because I'm just submitting, because today what will happen is, state has got the power in the new amendment. Potable alcohol fully comes within the state. Suppose tomorrow Parliament makes some law and doesn't bring it into force. The states can't be completely paralyzed or stultified. So I'm saying that the law made by Parliament will be a law only if it is brought into force. That's why Lordship saw in service tax, they added entry 92C, never notified it. So it was always under 97.
Right.
Deeply obliged.
Thank you, Mr. Patel.
Twenty 2012, 7 SC 106.
The cash on. That has taken away the list.
Intervention.
course.
So it's defined right and science.
In the form of question answers, whatever questions were referred, I gave the answers. But so many questions came from the bench, but I had to restructure it. With your lordship permission, I'll give a fresh submission.
No problem. Can give it by tomorrow also.
Can it be by Saturday? I have to go back to check.
All.
Yes.
The judgment you wanted to give.
Which one?
The judgment you
Mara
wanted.
Prem.
Yes, yes, 1997, sorry, 2007. 2012, 7 SEC, 106, it's a constitution bench,
106.
106. Mar Aparem Kuri Company Limited versus, sorry, State of Kerala versus Mar, MAR, Aparem, APPRAM Kuri.
06.
So they say repugnancy arises as soon as the law is made, even though it is not enforced or made notice. Last year,
It's there in the compilation.
it's in the company?
Yes, yes.
Oh, very good.
It's in volume 5, page.
I'm relying upon it and at my, when my turn comes. It's there in the compilation.
It's there in the compilation.
Volume 5,
5,
959. 5B,
page 2374.
Volume 5B.
5, volume
then
5.
it's come twice.
PDF page 2382.
2382.
2382. Volume 5.
Both sides are targeting this constitution bench judgment.
But finally, I appeared for state of UP. Yesterday, I was asked to appear for state of Tamil Nadu. Same submission. They've added something on duty of fee and taxes, which I'm not. I'll be appearing for that. This submission will be common for both.
Yes.
So the rules are the same. All. Deeply obliged.
Yes, Mr. Gupta.
My lord, my task is very light, my lord, and I won't hold your lordships up. My lord, I appear for the state of West Bengal, and my lord, unfortunately, there has been a little technical hitch. Our Wakalatnama is filed, my lord, in 901.28. Look, there is a small hitch, my lord. 901.28 is the matter in which, my lord, the state filed its wakalatnama. Now, my lord, the first thing which happened in this matter was that matter got detagged. So, my lord, we haven't filed it in any other matter. My lord, we'll file it. My lord, our written submissions, my lord, are volume 1 H. And my lord, and, my lord, the judgments which are not common to, my lord, what was already filed before us are in volume 5D. The judgments which were common, my lord, we have been told to take out because they are already on record. Now, my lord, there are two ways in which this matter is being analyzed now, my lord. So I'll just summarize very briefly, my lord. I am not adding, my lord, submissions to the first limb of the argument, which is based on the proposition that all alcohol is intoxicating liquor. And therefore all alcohol is under entry 8 except excise, which takes out a part of it.
No, entry 8 has no fiscal ramification.
It doesn't have, my lord. In any event, my lord, the fiscal ramifications are expressly provided for.
And so provided under separate heads.
Completely separate heads.
No, because you said except excise.
Yes.
That you need not.
No, that's right.
Not necessary.
That's only the end use of the product.
Your basic point is that all alcohol is intoxicating liquor and falls under entry 8.
Yes, my lord. Therefore, my lord, it is excluded from entry 24. My lord, I am just summarizing, my lord, what Mr. Dwivedi has already made it very clear to your lordships, my lord. So it's not included within entry 24. Therefore, not included in 52, list 1. And therefore, my lord, the entirety of the control should be with the state. So, my lord, I adopt that. I don't add anything more to it, my lord. The second aspect of this matter is, my lord, if your lordships do not accept that all alcohol is intoxicating liquor within entry 8, then what is the position? And, my lord, it should be pointed out, my lord, that this proposition was not accepted in synthetics, and so therefore your lordship will have to overrule synthetics on that aspect, that all alcohol is intoxicating liquor.
Has Mr. Datar left? Mr. Datar, you have to give us that Benion's citation on public law. Hmm? Yes. Because that issue has also arisen before us in the AMU case. Of course, that the issue is a little different, which, and we're not deciding it or commenting, since both the solicitor and attorney will have some objections if we did that, as to whether the union can do anything other than to support a union law. Can a union say that a union law is not a valid law? So broadly, jurisprudentially, it's the same thing. You know, in that AMU case, yes, that issue arose, Mr. Datar had a point because, you know, in synthetics, the union supported Balsara and said that entry 8 covers both liquor for human consumption and what is now called as industrial denatured spirit. So Mr. Datar wanted to refer to an article by Francis Benion in Public Law. Jurisprudential article. Attorney is also interested in jurisprudence, so it will be interesting to see what it is. So volume?
Volume 5, capital E.
Okay.
PDF page 41.
Just 1 second. Let me see where we are taking. Yeah.
5-E.
Very important. Volume 5E page.
PDF page 41. This is Public Law Volume 2007.
Then we went.
Lordship, since your Lordship asked, colleague just found out this executive estoppel, same article has been cited by Justice S.B. Sinha in two judgments. 2008, 12 SCC 466 and 2009, 16 SCC 569.
2008,
12 SCC 466 and 2009, 16 SCC 569. His
16
Lordship,
SCC 5.
569. 2009, 16 SCC 569. Both by Justice S.B. Sinha.
So you were on the second point now.
Yes.
And you said that alternately, if the court does not accept that all alcohol falls under entry 8,
Yes. In that case, my lord, synthetics has to be overruled on the simple ground that the threefold classification of Tikaram Ji followed up to today has not been taken into consideration at all.
what is the threefold classification of raw materials,
Raw materials,
manufacture and distribution? of
manufacture and
products?
production, and post-production. Pre-production, production, post-production. Only the second, that is production, is covered by the word industry. So therefore, my lord,
Post-production goes into entry 33.
not necessarily, my lord. It first,
Trade or commerce. Trade or commerce
first
is
is goes into 26,
27
26 and 27.
or 33.
It might go to 33 if the product itself is a notified industry.
Right.
The product,
The product.
not my lord, the product. Let us say in this case, industrial alcohol is the product. Let us assume. Denatured spirit, my lord, is the better word, as Mr. Datar has already pointed out.
The products of any industry,
Yes.
where the control of such industry is declared by Parliament.
That's right.
So it has to be the product of an industry which is declared by Parliament to be.
Correct. my lord. And if raw material is not that industry, it's not part of the industry, it might itself be a product.
Yes. It can be a raw material for some other product.
In this case itself, let's go straight away into, my lord, the real problem. The nub is here. Your lordship has seen the process. It starts from molasses. It goes to ENA, extra neutral alcohol. Extra neutral alcohol is then capable of use in two ways. First, by using denaturing compounds, it can become denatured alcohol and can only be used for industrial purposes. It cannot be used for consumption. Second, that same ENA can now be used for processing into potable alcohol. Now, assuming that your lordships do not overrule synthetics on the question of what is intoxicating liquor, what synthetics said was that in order to be intoxicating, it must be for human consumption, because the word intoxicating indicates that it is for human consumption. That, my lord, my learned friend has argued in detail, should not be the correct interpretation because of the legal meaning given to the phrase intoxicating alcohol, intoxicating liquor, long prior to it, including Balsara, etc. So, my lord, by overruling Balsara, synthetics said that intoxicating liquor means for human consumption. If so, If so, my lord, entry 8 at the very least will protect the state's rights on all aspects as far as potable alcohol is concerned.
So a valid point.
Yes.
Now,
You said that synthetics overruled Balsara by holding that intoxicating liquor covers liquor for human consumption.
right. If your lordship, my lord, does not accept my learned friend Mr. Dwivedi's argument, then that part of synthetics will continue to hold. That, my lord, is the springing point or starting point for the second set of arguments, my lord. The first set of arguments, my lord, is complete if your lordship accepts that intoxicating alcohol includes, intoxicating liquor includes all alcohol. Then you don't have to go into this second argument at all. But the second argument is also important because, my lord, the judgments so far have accepted that position and carried on after synthetics, naturally. Even under that, entry 8 would at least cover the entire process as far as potable alcohol is concerned.
Yes.
And my lord, here there is a little footnote. Whether or not we look at the amended IDR Act, that would be the position. Before amendment, the schedule to the IDR Act said fermentation products, alcohol, and the second heading. Yes. Even here, if intoxicating liquor included only potable alcohol, even then it would not be industry, it would not be subject to 52. Potable alcohol.
Because if potable alcohol is covered by entry 8, can't go to entry 20.
Can't go to entry 20. This has become even clearer after the amendment because the schedule now excludes potable alcohol categorically. But that was actually the position even before.
Post 2016, in any case, potable alcohol is out.
Because, my lord, it is no longer a notified product.
Right.
Now, we are left with, my lord, denatured spirit.
Yes.
Most of the process for manufacturing denatured spirit is common to the manufacture of potable alcohol. In fact, I'm not saying theoretically.
Yes.
Up to the stage of ENA, there is only one process.
Yes.
If the state imposes any regulations in the manufacture of ENA, it cannot make a distinction between the end product at that stage. At that stage, it is not known what is the end product.
Yes.
So, my Lord, Justice Jeevan Reddy in Bihar Industries said that at the point of removal is the appropriate point at which you have to look at the end use. Whatever goes for the manufacture of denatured spirit will remain in the control of the union, and whatever goes for production of potable alcohol will remain in the control of the state. But up to the point of ENA, whatever is done as far as potable alcohol is concerned will necessarily also happen as far as denatured spirit.
Because it is after the ENA stage that the denaturing is added.
That's
The bifurcation.
That's it. The bifurcation takes place after that. So we let's suppose, and I give your lordship a concrete example.
What is the sequitur, Mr.?
Just one concrete example. Several states, my lord, have certain restrictions on the input-output ratio of molasses to the final product ENA. If it is within the efficiency factor, then there is no measure. If it is outside, it becomes subject to penalty. Now, my lord, if the state imposes a efficiency factor in the process of manufacturing ENA, at that stage, it will get imposed both on the quantity which will ultimately be used for rectified spirit as well as the quantity which will ultimately be used for potable alcohol. So therefore, my lord, keeping that reality in mind, my lord, we have to proceed to the next stage to see where the control of the state should end and where the control of the union should start. Up to that point, it becomes impossible to make that distinction, because whatever I do for potable alcohol will necessarily also apply to the manufacturing process for ENA, which is ultimately used for denatured spirit. Therefore, my lord, now let us look at the legal analysis. My lord, this is a practical difficulty. Now let us look, my lord, at the legal analysis.
What happens after the process after the denaturant is added?
Yes. After denatured, the product has already come into being. So there, my lord, the the denatured spirit is actually in that second stage. Production and manufacture has been completed now of that product. After that comes the question of distribution, which will go into NT 33. Why? Because denatured spirit is certainly excluded by the schedule of IDR Act. So, my lord, the notified product, if I may put it that way, the notified product is the denatured spirit. Now, if I apply, my lord, Tikaram, the raw materials used for the notified product, denatured spirit, ENA, is within the state's power. The distribution of the product is within the state's power. And, my lord, it is very important for the reason, my lord, that even denatured spirit, as a matter of fact, can re-enter, my lord, or try to re-enter the potable zone and create havoc. So, my lord, if the state has no power to regulate what happens at the distribution stage, then, my lord, there can be havoc. What is ultimately causing all these huge tragedies is where denatured spirit diluted with water, mixed up with some genuine spirit like whiskey, cheap whiskey, is then sold, and that creates havoc. It can become. No, even ethyl alcohol. That's right. That is, you're saying that because it is in order to make it denatured. Yes. My learned friend is saying that in order to make it denatured, you make it methylated, you add methylated spirit, then it becomes denatured. It should not be used for human consumption anymore. But my lord, in the market, it sometimes comes back, and by mixing it with some cheap whiskey, it is sold. So, my lord, the distribution is also a very, very important stage, not only for my lord revenue purposes here, my lord. My lord, here, my lord, entry 6 becomes absolutely important because public health is a state subject. Entry 6 of list 2. So, my lord, both under entry 6 and entry 8, it becomes necessary for the state to control the entire process of potable alcohol, which sometimes goes across to the question, to the control of, my lord, the denatured spirit process as well. That's the factual background. Now, therefore, if I'm to analyze it now in terms of Tikaram, we'll put it into these 3 components, and only the middle component will be subject to union control, and the other 2 will either be state control, because, my lord, it is state control because of 26 and 27. Now the question is that if the product itself has become included in the schedule, ENA, suppose ENA becomes included in the schedule, then of course it will go to 33.
Right.
So far, my lord, the only thing in entry 33 will be denatured. That's the product which has been put there.
Yes.
Now, my lord, the simple point is, if you do not take into account Tikaramji's analysis, then you cannot reach the correct result. And Tikaramji has not been taken into consideration in synthetics. And my lord, the reason, my lord, I'm sure, is as Mr. Datar said, it was actually a matter relating to, my lord, tax. It all started with some provision of tax which was under challenge. It could have been decided on a much simpler basis perhaps, but 7-judge bench, so it went into all issues which were argued. Now, one more thing, my lord, one passage from Bihar Industries, my lord. Give me your page. Volume 5, page 72. 5D, page 72. 5A. 5A, page 72. Oh, because it was in the previous compilation. Not in my compilation, it is already there. Bihar Distillery. Bihar Distillery, my lord.
5A 72 is VAM Organics.
76.
76, my lord. PDF page 76?
Yes, Bihar Distillery is 76.
Actual page is 72. Here, my lord, let me just place 23. I won't take your lordship's time. Para 23. Wait. We are of the respectful and considered opinion. PDF page 91. We are of the respectful and considered opinion that the decision in synthetics did not deal with the aspects that have arisen for consideration herein, and that is mainly concerned with industrial alcohol, that is denatured rectified spirit. While holding that the rectified spirit is industrial alcohol, it recognized at the same time that it can be used for obtaining country liquor by diluting it or manufacturing IMFL. When the decision says that the rectified spirit with 95% alcohol content VV is toxic, what is meant is that if it is taken as it is harmful and injurious to health. By saying toxic, it does not mean that it cannot be utilized for potable purposes, either by diluting it or by blending it with other items. The undeniable fact is that rectified spirit is both industrial alcohol as well as a liquor which can be converted into country liquor just by adding water. It is also the basic substance from which IMFL is made. Denatured rectified spirit, of course, is wholly and exclusively industrial alcohol. This basic factual premise, which is not and cannot be denied by anyone before us, raises certain aspects for consideration herein which were not raised or considered in synthetics. Take a case where two industries A and B come forward with proposals to manufacture rectified spirit. A says that it proposes to manufacture rectified spirit and then denature it immediately and sell it as industrial alcohol, while B says that it will manufacture rectified spirit and utilize it entirely for obtaining country liquor and for manufacturing IMFL from out of it, or to supply it for to others for the said purpose. According to synthetics, next page, my lord, A is under exclusive control of the union, and only power the state are those which are enumerated in para 86. Those, my lord, were the limited powers which was given to the state under that judgment. But what about B? The rectified spirit manufactured by it is avowedly meant only for potable purposes. Can it yet be called industrial alcohol? Can it still be said that the state concerned has no power or authority to control or regulate industry B, and that union alone will control and regulate it until the potable liquors are manufactured? The union is certainly not interested in or concerned with manufacture or process of manufacture of country liquor or IMFL. Does this situation not leave a large enough room for abuse and misuse of rectified spirit? It should be remembered that according to many states before us, bulk of the rectified spirit produced in their respective states is meant for and is utilized for obtaining or manufacturing potable liquors. Can it be said, even in such a situation, that the state should fold its hand and wait and watch till the potable stage is reached? Yet another and additional circumstance is this: it is not brought to our notice that any notified order has been issued under 18G of the IDR Act regulating the sale, disposal or use of rectified spirit for the purpose of obtaining or manufacturing potable liquors, which means that by virtue of entry 33 of list 3, the states do have the power to legislate on this field. Field is not occupied by any law made by the union. And my lord, the next two sentences beyond that, my lord, the line of demarcation can and should be drawn at the stage of clearance and removal of the rectified spirit. Where the removal or clearance is for industrial purpose, the levy of duty of excise and all other controls shall be of the union. But where the removal clearance is for obtaining or manufacturing potable liquors, the levy of excise and all other controls will be of the state. This calls for joint control and supervision of the process, etc., etc. Now, my lord, I come to the next proposition.
Yes.
The next proposition is this, my lord, and this was actually highlighted in the questions which were referred in the Lalta Prasad order, and that was, my lord, with regard to 18G. The reason why it is being referred is, my lord, two things happened in synthetics. It was said that because it has gone into 52, the entire field is denuded, and so therefore 33 will not apply to give states any leeway. And secondly, that 18G is an indication that it has denuded the whole field. Now, my lord, a very simple, my lord, aspect to be taken into consideration is that 18G was in the statute books all along from 1953 or so, my lord. Now, even when Tikaram Ji was decided, it was there. Every time Tikaram Ji, my lord, has been upheld, it has been on the face of 18G. If so, my lord, how could raw materials go out? How could distribution, etc., go out if the whole field was denuded? So, my lord, what has happened is, if you do not look at Tikaram Ji's judgment, you will think that it is possible to hold that the field has been denuded. But if you look at Tikaram Ji and follow it through, then you cannot hold that the field has got denuded. Because, my lord, at least two aspects, my lord, are out. Now, my lord, we have given the list of all the judgments which has followed Tikaram Ji up to ITC. Well, I'm not, my lord, taking your lordship through those. There are just, my lord, two, there's only one more aspect, my lord, which I want to point out. And this is also, my lord, because of, my lord, specific difficulties which may arise later on. At this point of time, we are not discussing any specific statutes with relation to, my lord, this aspect. But, my lord, if your lordship holds, and to the extent that your lordship holds, that the state has the power to impose regulatory measures, my lord, it may take the form of matters other than regulatory fees. Moment we say fees, it becomes, my lord, a situation where you might be asked to show quid pro. Yes. Cost of regulation, my lord, must be shown to somehow have a correlation with the amount imposed. It may be a vague correlation or a loose correlation, but correlation has to be there. Whereas, my lord, in fact, regulatory measures may include, my lord, some kind of penalties to discourage a person from doing something. This is not something which is fees and therefore requiring quid pro. So, my lord, all that I'm saying is, my lord, that your lordships, if regulatory powers remain with the state government for whatever reason, my lord, then, my lord, such regulatory powers should not be restricted to regulatory fees.
Yes.
My lord, those are my submissions.
Thank you, Mr. Gupta. Mr. Giri?
Yes, my lord, licensing is a very important way of regulation. So that, my lord, also, and as your lordship has heard from Mr. Datta, the states, my lord, in fact, are my lord, the licensing authority for all industries, my lord, which are manufacturing ENA today.
Wait, please. I beg to appear in civil appeal number 6708 of 2014. I think that is 901.14. 14 and 117, let's say, on behalf of the state of Kerala. Lord, the impugned judgments were passed on the basis of synthetics and chemicals without getting into any other issue. That's why, my lord, when the appeal was filed, the appeal was admitted and, my lord, tagged along with the matters which are already referred. My lords, my lord, in my written submissions are contained in volume 1D, D for Delhi. There's one other point, my lord, which arises from a judgment of Constitution Bench of this Honorable Court, which has not been referred to, but which arose from the same enactment, my lord, that has been considered. I'll take your lordships to that in a moment, my lord. See, I've given, my lord, the citation to the court master so that it is not part of the compilation of judgments, but I think it has been uploaded. Let's see. But permit me, my lord, to make a basis for what I wanted to submit before your lordships. My lord, if your lordships were to consider that an industry which is engaged in the manufacture of alcohol per se, without coming to the distinction of whether it is potable alcohol, industrial alcohol, or, my lords, the industrial alcohol in the sense that it is unfit for human consumption, then, my lords, your lordships may construe 24, entry 24 of list 2. My respectful submission is that it would not take in, my lord, an industry which is regulated, my lord, by entry 8, my lord, of list 2. And intoxicating liquors, my lord, which is the prime question that your lordships have formulated for consideration, as falling under entry 8. Whether it to take in all, my lord, subsects of alcohol, except denatured spirit, my lord, which has to go out of, my lord, the purview of alcohol fit for human consumption, or which could be made fit, my lord, for, because then it would, according to me, my lord, it would not be an intoxicating liquor per se. Denatured spirit can never be treated as intoxicating liquor per se.
So you're arguing something at variance with what?
Yes, according to me, intoxicating liquor cannot take in denatured spirit per se, my lord. This is what I have tried to say, my lord, in my written submissions also. Except denatured spirit, which is a matter of manufacture. All other aspects of all other varieties of liquor would come under entry 8. Every activity which would be comprehended by an industry relating to any product is textually, my lord, covered by entry 8 insofar as intoxicating liquors are concerned. Production, manufacture, possession, transport, purchase, sale, every aspect of. Therefore, my lord, entry 24 will have to exclude, my lord, intoxicating liquors. Entry 24 of list 2. My lord, two hypotheses will not flow in my respectful submission. Going by 246, Article 246, and the general principles, my lord, which your lordships have laid down in innumerable decisions as to how to construe an entry in a list. My lord, the scope and ambit of entry 52 of list 1 will have to necessarily exclude any item, my lord, which is comprehensively covered by an entry, my lord, in list 2. And here, my lord, 24 would go out of the picture.
Now, what happens to denatured spirit then?
Denatured spirit, my lord, requires a manufacture of a specific commodity which does not become the raw material, my lord, for any other alcohol. My lord, there is no question of
Therefore, according to you, denatured spirit will be governed by IDRA?
Yes.
52.
Yes. The sequitur, my lord, is therefore, except denatured spirit, every other sect of alcohol, whether it is a final product or an intermediate product, would be covered, my lord, by entry 8. Let alone the question of levy of excise duty under entry 51. In fact, my lord, entry 51 of list 2 is treated to be complementary, and that's what your lordships have held in the judgment, to entry 84 of list 1. Because 84 of list 1, my lord, as it stood prior to the 101st amendment, specifically excluded it. And 51 specifically provides for it.
denatured spirit can come both under entry 24 list 2 and entry 33 list 3.
No, my lords, the entry 34 list 2,
24.
entry 24.
Because if if denatured spirit is not part of intoxicating liquor according to you under entry 8,
Yes.
then the sequitur will be that, denatured spirit is governed by the schedule to the IDRA.
If it comes under entry 24, then it becomes subject to 52.
Yes.
Right. So in which case it becomes part of item 26. If it does,
Yes, yes, yes.
right?
Yes, yes.
If it does, it's directly governed by entry 33 of list 3. It's
Yes.
a product of an industry,
Yes,
the control of which is declared by Parliament to be
Yes.
in the
Yes.
public interest.
yes.
In which case it would still be within the state's regulatory power until Parliament were to enact a law to the
Yes.
contrary.
Yes, yes. Until Parliament were to enact a law, my lord, in terms of,
ET&G also requires a notified order.
it requires a notified order. There's no notified
So,
order.
The little nuance which you are putting, I mean, not a little nuance, but the difference from what everybody else has argued is that according to you, denatured spirit is out of entry.
Completely.
But are you therefore arguing that Balsara is wrong?
My lord, Balsara really did not consider the distinction. My lord, Balsara went into the question of why are the provisions, my lord, which provided a restriction on the import of not rectified spirit, not denatured spirit, but liquor as such. And therefore, there was no occasion in Balsara, my lord, to consider the distinction.
That was
Not only that, my lord, prior to the constitution, all those local enactments, my lord, which Mr. Dwivedi has provided in his chart, all of them, my lord, also define, my lord, spirits as including denatured spirit, and the entirety of control of anything to do with alcohol, including denatured spirit, subject to correction, my lord, came within the province of the provincial legislature. It is only, my lord, when it came under the constitution. Sorry.
Even if we therefore really speaking, Mr. Giri, you are really in that sense arguing the second point, which
Yes.
Mr. Dwivedi.
Alternative submission.
The alternate,
Yes.
but the alternate submission which he argued is your main submission, in the sense that you are saying that there is no substance in their first submission. Therefore, the alternate submission is your main argument.
Saying that,
I will
I'm
say
not
that-
trying to take away anything from what they have argued. my lord.
Not at all.
That is something which your lordships will have to
Right,
consider.
right, but for denatured spirit,
Yes.
your argument is directly contrary to what the others have argued before.
In the sense, my lord, but it is not, my lord, in antagonism to that. It is not in antagonism to
No,
that.
but you are saying that denatured spirit does not fall within entry 8.
That's correct. Not only denatured spirit.
Only denatured.
I'm saying, my lord, are distinct from 95% ENA, which is what is considered, my lord, in synthetics and chemicals. In fact, my lord, synthetics and chemicals need not have gone into the question of ENA or any other aspect, because the persons who had filed a writ petition were, my lord, distillers or were manufacturers of denatured spirit. And it was one, my lord, it was apparently because a license was not granted or some fee was remitted, some fee was demanded, that they had approached the High Court also, even in the first instance in 91. But then, my lord, then the court, my lord, probably because, as Mr. Gupta put it, probably because it was argued before them, that their lordships probably felt it necessary to go into these aspects. But otherwise, denatured spirit, according to me, stands completely separately. It's manufactured, my lord, it's manufactured with a process that is unique to it. There is no question of extracting alcohol from denatured spirit thereafter. Nothing. There's no question of comeback. Denatured spirit by itself is a product that cannot be, my lord, used for, and according to me, it cannot therefore come under 8, because it's not an intoxicating liquor. One cannot, my lord, treat the word intoxicating as a surplusage. Intoxicating liquor means it must be fit for human consumption. A denatured spirit is not. Lord, why I beg to, my lord, try to bring it under this entry 8 is because then I don't have to fall under 24. And 24 may not take in anything which falls under 8. And if I don't fall under 24, my lord, I'm really not concerned with 52.
Anything other than denatured spirit
Yes.
is something which is, we'll not say alcohol fit for human consumption, but
Not-
alcohol for human consumption,
Alcohol for human consumption.
which has the potential for human
Yes, yes,
consumption.
yes, yes. My lord, there's
So
no,
you are appealing for the state of Kerala.
yes, yes. There's no rocket science,
So-
my lord, involved in
Correct.
converting ENA, my lord, into, my lord, either
Denatured.
country liquor or anything, my lord, which is
You add
normally
the
consumed.
denature and that's all.
Nothing, my lord, just add water to it. And then, my lord, for the purpose of labeling it in different, my lord, very attractive bottles, you either add caramel, then it becomes rum, you add malt, then it becomes whiskey, and then the others, I don't know.
Mr. Giri, it's yours theoretical analysis of the subject, you resume, therefore.
I'm saying I'll go by what Mr. Datar has provided in his chart. At page 12 of his written submissions, he has provided, this is how
You
it.
clarified by Mr. Datar has provided in his chart, not what Mr. Datar has provided.
No, my lord, I use the word chart.
So I think we've got the point. But therefore, you take it that you are paying for the state of Kerala, right?
Yes, my lord.
Therefore, you are not seeking to regulate or impose any regulatory fees on denatured.
No,
spirit.
yeah, we are not. Yeah. The issue, my lord, in the present case arises from, my lord, a demand for wastage fee on extra neutral alcohol.
So the wastage fee on it.
Yes. And that is how, my lord, it has come. No, my lords, there are 2 or 3 aspects, my lord, which may flow out of it, my lord. Can I proceed with it?
Yes.
No, my lord, insofar as the judgment in synthetics and chemicals are concerned, my lord, if Mr. Datar has taken your lordships, my lord, to some of the paragraphs, my lord, which in his submissions, my lord, he said this, my lord, will have to be treated as not acceptable, and therefore, my lord, has urged your lordships to consider whether they have to be overruled. My lord, could your lordships kindly come back to synthetics and chemicals, my lord, because at the end of the day, your lordships are considering the correctness of the judgment. Just your thing. Mhm.
question only. We will not go into the, the nitty-gritty of your particular
Yes.
provision, the wastage fee, as you said.
Yes. Sorry, I'm sorry, but I didn't catch it.
No, I mean, we need not go into state-specific legislation here. We are.
No, we need not. We need not. This is only, my lord, this is an additional string to the bow, if your lordships would kindly consider it that way. Without taking away anything, my lord, from the broad sweep of the argument which Mr. Dwivedi had made, that the alcohol which is mentioned in entry 8 would cover everything, every variety of alcohol. In my
Other than
respect,
denatured spirit.
in my respectful submission, it cannot include denatured spirit, my lord, because entry 8, my lord, makes it intoxicating liquor. And my lord, there is one product which cannot be treated as intoxicating, my lord. Intoxicating would mean intoxicating for the human being, which means it must be consumed by the human beings. And it cannot be. There is no process by which a denatured spirit can be made into, my lord, consumable alcohol, as it were, or potable alcohol, as it were.
Correct.
And therefore, my lord, entry 8 will have to exclude that. Except that if every other variety is therefore included in entry 8, my lord, the sequitur, in my most respectful submission, forgive me for repeating, my lord, I don't have to concern myself with entry 24. And if I don't have to concern myself with an entry 24, then really speaking, my lord, I don't have to concern myself with 25 or 27. Because that is every aspect of it is, my lord, covered by entry 8. Because, my lord, I fall under entry 33, my lord, I have to take resort to entry 33 only when the parliament may by law, my lord, declare that any industry is one of public interest as such. Where therefore, my lord, the parliament cannot.
Therefore, when you say that therefore denatured spirit
Yes.
does not fall within the fold of entry 8,
Yes.
it necessarily therefore
Yes.
may fall under entry 24 and therefore under entry 52.
Yes. Yes.
But if it falls under entry 52,
Yes.
then the state's regulatory power, even insofar as denatured spirit,
Correct, my lord.
would be subsumed in, say, entry 33 of list 3 then.
Correct. Correct, my lord, it could. But, my lord, in my respectful submission, it is not necessary to get into that orbit at all, my lord. If your lordships are pleased to hold that the intoxicating liquor as contained in entry 8 would contain any other species of alcohol, as it were, except denatured spirit, because it can never become, my lord, manufacture is the ultimate stage, my lord, of a production. A production, therefore, my lord, would have intermediate stages. ENA, my lord, is one of the products which you get in the manufacture of, my lord, Indian made foreign liquor. Molasses is another product. And from molasses, my lord, fermentation takes place. Extra neutral alcohol is obtained, which could be 95.5%. But that's alcohol, my lord, which would still fall within the ambit of.
The state of Kerala's position, therefore, that the states will not have any role whatsoever to play in regard to denatured spirit.
No, my lord, in my respectful submission, if this argument, my lord, even otherwise, my lord, we don't do anything with denatured spirit. That's what I wanted to get myself clarified. We have nothing to do with denatured.
You may not be doing it, but ultimately, what is your submission?
Of states' powers.
About
States'
the power of the
powers, my
state?
lord, states' powers. For example, my lord, for setting up a manufacturing unit of denatured spirit per se. Lord, I don't think they have to, they have the power to issue a license, and therefore they don't have the power to regulate.
No, but licensing, as
Yes.
you are told, is for the alcohol manufacturing,
Yes,
right? At the stage when license is issued, it is not issued for industry A, industry B, two categories. It is issued, then the end product will determine whose control it will be.
there, my lord, there is.
Therefore, at the
No.
time of issuing license, that's what
Yes,
we are given
yes.
to understand.
Yes, my lord. Suppose it is for manufacture of extra neutral alcohol per se, then obviously the state would have the power. But the question as to whether it gets into denatured spirit or not comes about at the stage of clearance.
Yeah, that's right. So at the
That's
time
insofar as a taxing power
At
is
the
concerned.
time of issuing license, that distinction is not there.
My lord, they'll have to say what they are going to manufacture.
No, also an example was given. Let us say at a given point of time, an industry license it has,
Your lordships are right.
it is manufacturing.
I-
And there is
I
a, say,
stand corrected, your
prohibition is
Your
imposed,
lordships are right.
say Bihar.
Yes.
Then what happens? He has a licensing, he has a factory, But that demand for the product is not there. For the
Portable alcohol.
portable, which gives a kick.
Yes.
No demand for that. Then
No, my lord. He has a license for manufacturing, he has a license for producing extra neutral alcohol. But does he have the license, my lord, to produce denatured spirit?
denatured spirit is at this stage of removal.
No, denatured spirit is also a
There is
product of.
also a levy, we are told, or at the stage of denaturing, you are imposing a fee that now you are putting denatured elements.
That's only they say that that's at the stage of clearance. Therefore, when it gets into the stage of manufacture of denatured
Up
spirit.
till the factory gate,
Yeah.
up till the factory gate, it remains in the purview of the state.
In which case, my lord, in which case, insofar as regulatory control is concerned, if it falls outside entry 8, it could still fall, my lord, under 24. In which case it will be subject to, my lord, to entry 33, 52 and entry 33. My lord, I really don't have to go to that extent, my lord, insofar as all other varieties of liquor except denatured spirit is concerned. It's only for that purpose that I see. But what fell from your lordships that the fact that it doesn't fall under entry 8 does not completely take it out of the purview of list 2. Your lordships are right. It could then fall under entry 24. It's an industry. If it falls under entry 24, my lord, it is then subject to entry 52 of list 1. If it is subject to entry 52 of list 1, then it is subject to entry 33 of list 3. In which case, my lord, possession, transport, and all those things, my lord, could come under the regulatory control of the state as well. I'm saying, my lord, I'm taking it from the point of view of exclusion, my lord. Except denatured spirit, all other varieties of alcohol would come under, and we are really concerned with intoxicating liquor fit for human consumption in this. For human consumption. My lord, my attempt is only this. Bring it under entry 8, then I don't have to come and I don't have to bother with entry 24. If I don't have to bother with entry 24, then I'm not bothered with entry 51 also. And then, my lord, entry 33 of list 52 also, my lord. Then I don't have to bother with entry 33, my lord, of list 3. For all varieties of alcohol, which would come under the broad category of intoxicating liquor, under which rectified spirit will never, I'm sorry, my lord, denatured alcohol will never come under. The other sequitur, the other consequential question, would your lordship then say denatured spirit is completely taken out of the purview of list 2? No. The lordships are right. The lordships are right. But I really don't have to labor on that, because in my respectful submission, my regulatory control is on the question of, my lord, the potable or intoxicating liquor, which is fit for human consumption.
That's all, Mr. Giri?
No, my lord, I need another 15 minutes.
All right, 15 minutes, and then now we're only left with Mr. Shadan Farah, sir.
Mr. Balbir Singh was in.
10 minutes, 15 minutes, and then
Not more than 20 minutes.
all.
But Mr. Giri, you are sitting here from yesterday. So arguments of Mr. Dwivedi did not have intoxicating effect on you. You are having something contrary to that.
I don't know, sir, my lord. They have the potential. They have the potential of doing it.
So, Mr. Giri, you are suggesting that entry 8 gets kicked in only when the liquid has the potential to give a kick.
Give a kick.
That's wonderful.